अब तो चलेगा, इनका 6 हफ्ते चलेगा।
May I have your lordship's permission to commence the proceedings of the court?
Yes. My esteemed colleagues on the bench, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, all the law officers, Mr. Vikas Singh, President of the Supreme Court Bar Association, Mr. Pradeep Kumar Rai, Mr. Rahul Kaushik, Mr. Manoj Mishra, President of the Supreme Court Advocates on Record Association, members of the family of late Justice A.M. Ahmadi who are present here and those who have joined us virtually, learned senior members of the bar, ladies and gentlemen. In assembling together, we pay our homage and tribute to one of the finest minds and a true friend of our legal fraternity, Justice Aziz Mushabbar Ahmadi, former Chief Justice of India. He completed his mortal journey, having led a full and fulfilling life, on 2nd of March. Our country has lost a jurist of a historic stature. As a young adult, Justice Ahmadi wanted to join the Merchant Navy and was selected. However, the selection letter was opened by his father, who himself was a judge in the district judiciary under the erstwhile state of Bombay. His father disapproved of the idea, and as fate would have it, Justice Ahmadi ended up following his father's footsteps. He often said that he did not choose law, but rather the law chose him. Justice Ahmadi was a man of many parts. He played cricket with the noted cricketer Salim Durrani, who passed away exactly a month after him on 2nd of April 2023. Justice Ahmadi began his legal career in 1954 when he started his practice at the bar in Bombay and later enrolled as an advocate of the High Court of Gujarat after the reorganization of states in 1962. As a member of the bar, he was among the pioneers of the legal aid movement in Gujarat. His legal acumen and advocacy skills were recognized soon enough, and he came to be appointed as a judge in the City Civil and Sessions Court of Ahmedabad in 1964. Appointment to the City Civil Court in those days was a stepping stone to a call to the bench of the High Court. In an interview, Justice Ahmadi narrates that he had no inkling of his appointment, and when Chief Justice J.M. Shelat offered him judgeship, he took some time to consult his family and especially his wife. He wanted to know whether his wife would be willing to live the life of a judge's spouse. In the end, Mrs. Ahmadi agreed. His children, Huzaifa and Tasneem, told me that Justice Ahmadi had a poor sense of direction and would often rely on his wife to guide him to the destination. His wife, Amina, was truly his guiding light in life. With her support and partnership, Justice Ahmadi rose from the ranks and was elevated to be a judge of the Gujarat High Court in 1976, and thereafter a judge of this court in December 1998. Justice Ahmadi holds the distinct honor of handling the judicial process at all three levels of the judiciary. Justice Ahmadi served this institution with consummate dedication and a fierce devotion to fairness, equity, and justice for 9 long years. He assumed the mantle of the Chief Justice of India on 25 October 1994 and became the 26th Chief Justice of India. The records of the Supreme Court registry reflect that Justice Ahmadi was a member of the bench in 811 judgments, of which he himself had authored 232 judgments. Justice Ahmadi was at his inimitable best in the courtroom. As a judge of exceptional intellectual abilities, he made significant contributions to the development of law, advancing the cause of secularism, substantive equality, freedom, dignity, and liberty. Some of his notable judgments include S.R. Bommai, L. Chandrakumar, Indira Sawhney, and Keshav Mahindra, dealing with the Bhopal gas tragedy. In S.R. Bommai versus Union of India, Justice Ahmadi wrote a separate 37-page judgment in which he emphasized the importance of accommodation and tolerance towards vulnerable religious, social, and linguistic groups, and concluded that adequate provisions had been enshrined in the Constitution to keep, as he said, divisive forces in check. In L. Chandrakumar versus Union of India, writing for the bench, Justice Ahmadi held that the power of judicial review vested in the High Courts and in the Supreme Court, enabling legislative action to be subjected to the scrutiny of superior courts, was an integral and essential feature of the Constitution, constituting part of its basic structure. In Alauddin versus State of Bihar, he laid down the procedure to be followed by judges in the matter of sentencing in terms of Section 235(2) of the Code of Criminal Procedure, 1973. He said that this provision is salutary and must be strictly followed. He held, and I quote, "When the court is called upon to choose between the convict's cry, 'I want to live,' and the prosecutor's demand, 'he deserves to die,' it goes without saying that the court must show a high degree of concern and sensitiveness in the choice of sentence. It need hardly be mentioned that in many cases, a sentencing decision has far more serious consequences on the offender and his family members." Justice Ahmadi was not one to shy away from writing a dissent where he believed that it was essential. He, along with Justice S.P. Bharucha, dissented with the majority view in the acquisition of certain areas of Ayodhya Act, holding the act to be unconstitutional. Aside from being one of the finest jurists, Justice Ahmadi was a great administrator, for the case pendency dipped to an all-time low during his term as the Chief Justice of India. When Justice Ahmadi joined the Supreme Court, he noticed that the total use of computers in those days was hardly 3% of its optimum capacity, and they were merely being used as word processors. When he took over as a chief, he transformed the way the Supreme Court used technology. He introduced computerized cause lists and made formal and extensive use of computers in the routine functions of the law. He built on the skills and management principles which he had devised during his time in the trial court and developed a method of categorization and classification of cases. After the successful categorization of cases, he got the docket pendency analyzed and took the challenge head on. He often had the slogan, "Don't get scared by numbers." Lord Justice Harry Wolff, the then Chief Justice of England and Wales, who welcomed Justice Ahmadi as the honorary master bencher of the Middle Temple, London, referred to him as the case cracker due to his success in reducing pendency of cases in the Indian Supreme Court. Justice Ahmadi has set the bar really high for his successors to follow. Justice Ahmadi extended active support to young advocates and encouraged them to appear before him. He made digital copies of judgments available so that junior members of the bar, in particular, those who could not afford the high costs of procuring books, could access the floppies and the CDs prepared by the Supreme Court. In an interview, he said that the basic idea was to ensure that junior members will have the advantage of a well-equipped library for that matter. His first step in increasing access to the judgments of the Supreme Court aided in increasing access to justice. Justice Ahmadi firmly believed in promoting young talent. In 1995, he formally introduced the system of judicial clerkships at the Supreme Court by employing a then fresh graduate, Arun Kumar Tiruvengadam, now a professor of law, as a judicial clerk. Justice Ahmadi often relied on the judicial law clerks to assist him in research and was open to their ideas and opinions. His dedication and devotion towards law, coupled with the aim of imparting quality education and encouraging young law students, did not let him stop after his retirement. and he accepted the position of chancellorship at the Aligarh Muslim University. He was conferred with several international recognitions and honorary degrees. He was a member of the American Inns of Court and was conferred a degree of Doctor of Laws honoris causa by the University of Leicester, England. He was nominated to various international committees and led several delegations and missions to East Timor, Liberia, Bangladesh, and Zimbabwe. When I had been offered judgeship, I had the opportunity to seek the advice of Justice Ahmadi. He was one of the arbitrators of a 3-member arbitral tribunal where I was representing the Reserve Bank of India in a dispute with a Canadian banknote company. On the last date of the arbitration in Ottawa, Canada, I sought an appointment with Justice Ahmadi for a personal matter. With a heart ready to help, he readily gave me sage words of wisdom. As I was still contemplating on whether to continue with my decision to accept judgeship, I asked him whether, after having spent his entire career in service, he still thought it was all worth it. Without a moment of hesitation, Justice Ahmadi said, "Absolutely worth it. I have not regretted a moment." And he said to me, "Do not look back, for I have never looked back." The life so well lived by Justice Ahmadi shows that the value of a true leader lies in the next generation, which he inspires and mentors through his words and actions. Justice Ahmadi has influenced multiple generations of lawyers and judges, including me, with his exceptional life. Throughout his illustrious career, Justice Ahmadi was known for his tireless work ethic, sharp intellect, and unwavering fidelity to the highest constitutional ideals. He was a beacon of hope for those seeking redressal through the legal system and was respected by all for his integrity and impartiality. Justice Ahmadi shared an unbreakable bond with his wife, who predeceased him by 6 months. There is an abiding photograph of both of them sharing a tender coconut, a dab as we say in Bangla, or a shahada as we say in Marathi, and smiling contently and peacefully. 2 straws sipping a single tender coconut. About his wife, he once said, "She is an unsung hero who always believes in work and not credit. To me, she is a great life partner, friend, and guide who also had a great sense of understanding and respect. She has indeed made my life easy and happy. I'm highly grateful to Allah for giving me such a nice life partner." As I said earlier, since she provided directions to him when he drove his Fiat car, he would joke that she is his guiding light. What my own elder sister said of my parents applies or describes the relationship of Justice Ahmadi and the spouse. They were truly a package deal. On a flight from Delhi to Mumbai, when I was a young lawyer, I happened to occupy the seat next to Justice Ahmadi while his wife was seated across the aisle. When I offered my seat for her to occupy, Justice Ahmadi waved me to sit by him and tell him something about the legal profession as a young lawyer saw it. The monsoon flight to Mumbai was bumpy, and Justice Ahmadi muffled to me, "Watch my wife," he said. "She will start praying soon." Soon thereafter, I saw Mrs. Ahmadi pull out a copy of the Quran as she started reading it for protection for her and everyone else on the flight. He knew her truly well. Justice Ahmadi had a sense of humor without being trenchant. The noted astrologer Bejan Daruwala was a college friend. When he asked young Ahmadi whether he could read his horoscope, he replied, "How much will you pay me if I allowed you to read it?" Justice Ahmadi is survived by his children, Mr. Huzaifa Ahmadi, a distinguished senior advocate at our bar, and Ms. Tasneem Ahmadi, a leading lawyer at the Supreme Court, his daughter-in-law Insia Ahmadi, and his beloved grandchildren Insia, Adnan, and Ali Asgar. In an article in the Indian Express on 11 March 2023, his granddaughter Insia Vanvati writes that Justice Ahmadi always took out time for his family, whether it was to play a game of table tennis after the 9 p.m. news or to engage in deep and meaningful conversations about life and law. His family and confidants had the unique pleasure of observing Justice Ahmadi and learning the essential lessons of integrity, conviction, and courage under fire while maintaining dignity. Insia Vanvati captures the great loss that the legal community and the entire country feels on the passing of Justice Ahmadi. She writes, and I quote, "Although he no longer walks amongst us, and the world feels like a light has gone out without him, his legacy and memory live on forever in the hearts of all those who had the privilege of knowing him. We extend our deepest condolences to his family, friends, and colleagues. When our parents are no longer with us, fond memories and their values provide sustenance to our lives. We pray to the Almighty to give strength to the members of his family and to bear the loss, as well as to have the wisdom to pursue his values. May we find the strength and courage to carry Justice Ahmadi's legacy forward." Attention.
Honorable the Chief Justice of India, Honorable Judges of the Supreme Court, Solicitor General of India, the Additional Solicitor General, President and Office Bearers of the Supreme Court Bar Association, President and Office Bearers of the Supreme Court Advocates and Record Association, esteemed members of the Justice Ahmadi family, members of the bar, ladies and gentlemen. We have gathered here today to pay tribute to the extraordinary life and legacy of Chief Justice A.M. Ahmadi, the 26th Chief Justice of India. When we gather to remember the life and times of great contributors to administration of justice, we are engulfed by a sublime environment. All minds become keen to gather the enriching memories about the life and contributions of such persona. I understand that these sublime feelings with themselves are a great persuasion to collectively stand by the noble values and goals passionately pursued by such contributors. Chief Justice Ahmadi, it can be well stated that he dedicated the entire life in the path of administration of justice in its manifold sense. By his extensive contributions in the field of law and justice, spread over several engagements and dimensions of such pursuits, the riches that have been added to the field of justice are immeasurable. With his passing away on March 2023, we mourn the loss of a great legal luminary. Destiny assigned various duties to be discharged by him, transitioning from a lawyer to serving as a civil and session judge, holding the position of a law secretary for the state of Gujarat, and in due course getting elevated as a judge at the Gujarat High Court. The sum of all the above contributions marked him as a definite candidate to becoming a judge of the Honorable Court. His contribution to the development of criminal jurisprudence are noteworthy, particularly Keshav Mahendra was State of MP on the intent part under Section 304A of the Indian Penal Code in the context of the Bhopal gas leak tragedy. Sanjay Dutt was a state on the indefeasible right of the accused to be released on bail within the tight scope of the scheme of Tada. Amir Shad Khan was a Himingalyana, emphasizing the dual obligation of a detaining authority. Niranjana Singh was Jitendra Bhimraj on the strict construction of terms of imprisonment under Tada. These judgments and some of the important dimensions of criminal law and procedure, laced with keen insights, continue to shape the law. In the Philippine encounter deaths matter triggered by the writ petition filed by Mr. R. Surya, advocate, Chief Justice Ahmadi stood firmly in endorsement of the intervention by the court. Justice Ahmadi also found that it is the duty of the court to keep at bay attempts to stall such proceedings, which happened in the writ petition filed by an inspector of police claiming to act in a representative capacity on behalf of the UP police force. The opinion of the court is an example of the balance between the credibility and impartiality of an investigation without casting any reflection on the police force. The court engaged in a noteworthy analysis of Article 142 of the Constitution. After referring to the Delhi Judicial Service Association case and the Union Carbide Corporation case. This analysis is a further reflection of the Honorable Judge's keen perception of the unique feature of Article 142 of the Constitution, elevating its importance consistent with the necessary restraint that will go into the invocation of Article 142 of the Constitution. Two thoughtful opinions penned by Justice Ahmadi deserve acknowledgement. The observation made in RKJ in the Union of India has set in motion over a period of time the importance of looking at sound tribunalization with due importance to the independence of the judiciary. the principle of suspension of a conviction of a sentence in the context of avoidance of disqualification laid down in Ramnarang versus Nameshwarang pertaining to a director of a company, anxious to avoid disqualification, has now become part of the law of suspension of conviction with its inroads into election law. If one has to quickly scan the length and range of fields of law visited by judgments such as Ahmadi, we can see that it extends and the importance of the right to know about the affairs of the government formulated in Dinesh Trivedi's case, the importance of the right to exhibit or broadcast in Doordarshan, a work critical of the governmental functions, as propounded in LIC versus Madhubai Shaw, the question as to whether a person who is not elected as a member of either House of Parliament can be sworn into the Prime Minister, touching upon the interpretation of Article 75, among other provisions of the Constitution, answered in a fine balance of logic, relevance, and representative democracy, rendered in SP versus H.T. Devagowda, a few indelible dimensions of jurisprudence. Justice Ahmadi's dissenting view in NDMC versus State of Punjab, where he voiced a strong opinion against the court lapsing into dealing with issues not directly raised in the proceeding, is a caution forever to be kept in mind. The narration will be incomplete if we don't advert to the milestone laid by the court in the TN session case, which has added strength and substance to the election law of the country, as also the judgment in NHRC with the state of Arunachal Pradesh, with an unqualified emphasis on the life and liberty right under Article 21 of the Constitution. How can one close one's attention to three other seminal constitutional contributions rendered in Bommai, Indira Sani, and L. Chandra Kumar? No part of the important chapters of a constitutional adjudication remain uninfluenced by this opinion. In one sense, S.R. Bommai and Ismail Faruqi stand together in the staunch advancement of secularism. The post-retirement life of Chief Justice Ahmadi bears testimony to his compassion and commitment to several human causes as well as social interests. He passionately engaged himself in the activities of the Bhopal Memorial Hospital Trust on his appointment as chairman. Records show that Justice Ahmadi played a significant role in the establishment of the Bhopal Memorial Hospital and Research Center. It is said the service rendered by him is visible in the commendable quality of medical treatment made available to the gas victims, and the hospital remains even today as an important center of medical care. It's just a matter of course that he received several international recognition. His work in the amelioration of human rights violation in East Timor is exemplary. Justice Ahmadi's contribution to the cause of legal education and laying emphasis on the importance of clinical legal education and attainment of equipment, coupled with ethics, continue to inform the Bar Council of India in its ongoing engagement in the cause of legal education. The recommendation made by the committee headed by Justice Ahmadi towards important amendment to the Protection of Human Rights Act 1993 in strengthening the NHRC with least governmental intervention is yet another illustration of the balancing of principles in conflict. His pioneering work as executive chairman of the Committee for Implementing Legal Aid Schemes opened up new avenues. I was fortunate to receive an autographed copy of his book, Flow of Thought, at the time of its launch. At a personal level, Chief Justice Ahmadi will be forever remembered by me as the Chief Justice who was instrumental in my designation as senior advocate. In addition to having been chairman of several advisory boards and Gujarat State Pay Commission and member of the Ravi and of the Water Dispute Tribunal, Justice Ahmadi served as the distinguished chancellor of Aligarh Muslim University for more than one term. Ahmadi's legacy is not only defined by the remarkable judgment, but also by his dedication to nurturing young talent. In conclusion, let us remember that A. Ahmadi is a beacon of justice, a champion of equality, and a tireless advocate for the rights of all. His legacy will continue to guide us as we strive to build a more just and inclusive society.
Honorable the Chief Justice of India, Dr. Dhananjay Chandrachud, Honorable Judges of this Court, Learned Attorney General for India, Shri R. Venkatramani, Shri Tushar Mehta, Learned Solicitor General of India, Law Officers of Government of India, members of the family of late Justice A.M. Ahmadi, members of the Executive Committee of the SCBA, Shri Manoj Mishra, President SCORA, members of the Executive Committees of SCORA, members of the Bar, ladies and gentlemen. Today we have assembled here to honor the legacy and pay homage to Justice A.M. Ahmadi, who made immense contributions to constitutional jurisprudence of our nation. Justice Ahmadi was born on 25th March 1932 in Surat, Gujarat, hailing from the Dawoodi Bohra community. He was the son of a junior civil judge. His father's decision to enroll him into the science stream made Justice Ahmadi realize the hard way that science was not his cup of tea. Thereafter, he decided to join the field of law. He did his first year of law from Sir L.A. Shah College in Ahmedabad, but upon his father's transfer to Surat, he completed law from the Sarjanic Law College, Surat. Clearing the enrollment examination in first attempt, Justice Ahmadi began his career as a lawyer in 1954 by enrolling as a district pleader in the Bombay High Court and commenced his practice thereafter in Ahmedabad. It is worthy to mention that Justice Ahmadi donned many hats, from a lawyer to being appointed as a judge in the City Civil and Sessions Court for Ahmedabad, as Law Secretary to the State of Gujarat, then as a judge of the High Court of Gujarat, and ultimately being elevated to the Supreme Court. I remember reading somewhere that Justice Ahmadi had no inkling for his appointment as a City Civil and Sessions judge. One day he was called to the Chief Justice J.M. Shaila's chamber. Justice Ahmadi was quite nervous as to why he was summoned. During the meeting, after talking about several things, he was offered the position, thoroughly surprising him. He sought time to consult his family, especially his wife, as he needed to know if she would be willing to be a judge's wife. Justice Shailat, however, asked Justice Ahmadi not to reveal it to anyone, as it was supposed to be kept a secret. Justice Ahmadi immediately responded by saying that his answer would be a no, as he could not take such a momentous decision without consulting his wife. Thereafter, Justice Shailat reluctantly allowed Justice Ahmadi to consult his wife, who finally agreed. During his tenure as a judge of the Gujarat High Court, who served as a member of several advisory boards, such as Advisory Board under the Conservation of Foreign Exchange, Prevention of Smuggling Activities Act 74, Prevention of Black Marketing, Maintenance of Essential Commodities, and the Gujarat State Third Pay Commission. He also served as a member of the Ravi Vyas Water Disputes Tribunal, Punjab Settlement. He served as president of the Supreme Court Legal Aid Committee and as an executive chairman of the Committee for Implementing Legal Aid Schemes in India. On 25th October, he was appointed as the 26th Chief Justice of India, the third Muslim Chief Justice of secular India, after Justice Muhammad Hidayatullah and Justice Mirza Hamidullah Beg, and continued to serve in that capacity for more than 2.5 years. Justice Ahmadi was known for his sharp legal mind, his commitment to justice, his integrity, and made countless noteworthy contributions in shaping legal education. Widely regarded as a visionary in the legal field, he laid the foundation for modern day legal education and its continued evolution. A judgment should be drafted when read is able to explain the complex and vexed question of law and facts to a stranger. A perusal of judgments authored by Justice Ahmadi would reveal how complex legal is can be explained in simple and understandable terms. It is no secret that Justice Ahmadi was a hard taskmaster and an able administrator. His administrative skills bore results when, by the end of his tenure as Chief Justice, the pendency of cases came down to 1800 from 1,20,000, as told by him in an interview to the Bar and Bench published on 7th August 2014. As Chief Justice, he ensured the usage of computers was expanded to their optimum capacity. Notable examples are the classification and categorization of cases and making caseload available in digital format. He was aware and sensitive towards the obstacles faced by junior members of the bar in accessing judgments, as many could not afford subscription to libraries and purchase expensive books. Thus, an endeavor was made during his tenure to prepare reasonably priced CD-ROMs and floppy disks to aid them. Justice Ahmadi is also to be credited for starting the judicial clerkship in the Supreme Court. Justice Ahmadi was very good to the junior bar. I once overheard him telling someone while he was Chief Justice that I can ensure SLPs come in 3 days, but that will affect the mentioning which go on for juniors. It will only allow them to mention and not dismiss mentioning. It helps the junior bar. I personally have been having very strong, fond memories of appearing before Justice Ahmadi as a junior member of the bar then. In Ismail Faruqi versus Union of India, Justice Bharucha and Justice Ahmadi formed part of a minority judgment. In the judgment authored by Justice Bharucha, the minority found the acquisition of certain areas at Ayodhya 1993 to be unconstitutional. They opined that the act limited to Muslim communities' ability to seek justice by preventing them from pleading and demonstrating adverse position. The court determined that such a limitation was against the fundamental principles of the Constitution and antithetical to the notion of secularism. While setting aside the act, the dissenting opinion noted, Ayodhya is a storm that will pass. The dignity and honor of the Supreme Court cannot be compromised because of it. In 2008, Justice Ahmadi released a book titled A Guide to Uplift Minorities, brought out by Jamaat-e-Islami Hind to help and guide the social workers who were active in the field of welfare of minorities. The 207-page book was meant to guide the non-government organizations working for the minority communities to run their programs effectively with effective aid from the government and other funding agencies. He was a staunch champion of human rights, and beside his profound contribution to the Indian judicial system, he, at the behest of the United Nations International Court of Justice, World Bank, and International Bar Association Human Rights Institute, led several delegations and missions to East Timor, Liberia, Bangladesh, and Zimbabwe, respectively. After his retirement, he was invited to speak at various universities and forums worldwide. In India, he used his status to speak on political issues such as minority rights. He was a man of staunch conviction and belief who remained unfazed by criticism of the media. He was widely known for his professional qualities. Not many know that he was also blessed with a great sense of humor and full of stories, humorous stories. He was occasionally tempted into a game of Ludo or table tennis. Justice Ahmadi had a naughty side to him also. During his college days, it was compulsory to have headlamps on cycles which were never switched on during evening. If not, then the police used to stop and confiscate the cycle. While Justice Ahmadi used to cycle, he used to remain the light, he would put the light on. But once he reached near the police station, he would purposely switch it off. The police went stopped him, to which Justice Ahmadi used to reply, no, it was working. Check it once, the bulb is warm. He used to thoroughly enjoy these episodes when the police had no option but to let him off, as the bulb indeed remained warm. Justice Ahmadi was extremely close to his wife, late Amina Ahmadi. She was his tremendous pillar of strength who stood by him through the difficult and trying times. Her demise in August 22 was probably the biggest loss in his life. Since her passing away, Justice Ahmadi was dispirited and probably lost the will to live. Justice Ahmadi was also culturally active. He used to be a member of the Navratra committee that used to be there during Navratri season in Gujarat. He liked and took a lot of interest in gardening. While he was in the High Court, he had bonsai plants of his own. However, due to grueling work schedules in Supreme Court, he could not pursue that interest here in Supreme Court. His children never practiced in Supreme Court while he was a judge in the Supreme Court. He was of the firm belief that it was desirable for the institution that children or relative of sitting judges do not practice in Supreme Court. He left for his heavenly abode on 23rd March 2023. He is survived by his son Huzaifa Ahmadi, an eminent senior advocate of this court, and his daughter Taslim, also a very eminent advocate. I offer my deepest condolences to the family on behalf of the Supreme Court Bar Association.
May I request all of you to stand up to observe 2 minutes silence in memory of late Honorable Chief Justice A.M. Ahmadi, former Chief Justice of India.
May I have your lordship's permission?
Yeah.
May I have your lordship's permission to conclude the proceedings of the court?
Normal court work will resume at 11:30 a.m.
ರಾಹುಲ್ ಜಿ ಅವರೊಟ್ಟಿಗೆ ಪ್ರಶ್ನೆಗಳನ್ನು ಕೇಳಬಹುದು. ಅವ್ರ ಜೊತೆಯಲ್ಲಿ ನಮ್ಮ ಪ್ರತಿನಿಧಿಗಳಿರ್ತಾರೆ.
Rahul sir, here. Rahul sir, this side.
ನಮಸ್ಕಾರ
Sir, this side, sir. Sir, here.
ಹೇಳಿ, ಈಗ ಪ್ರಶ್ನೆ ಕೇಳಿ.
Sir, ಇಲ್ಲಿ. Sir, ಇಲ್ಲಿ. Left ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ ನಿಶಬ್ದವಾಗಿರಿ, ಅವ್ರ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಸರ್, ಇಲ್ಲಿ ನಾನು ಕೇಳ್ತಿರೋ ಪ್ರಶ್ನೆ ಮೀನುಗಾರರ ಪರವಾಗಿ. ನಾನು ಚೇತನ್ ಬೆಂಗ್ರೆ ಅಂತ ಸರ್. I am Chetan Bengre, sir. I met you 22 years back. We all love you, Rahul sir. Thank you for coming and asking some questions to us. Sir, last time we had discussed in Mangalore.
Hello.
In Lady Hill.
Sir.
Regarding the dredging is very much important.
ಸ್ವಲ್ಪ ಮೈಕ್ ದೂರ ಇಟ್ಕೊಳ್ಳಿ ಬಾಯಿಂದ.
The dredging is not happening in Karnataka. Dredging. The dredging is not happening in Karnataka throughout Mangalore to Karwar. And the second thing is you promised us now the diesel is coming from 300 to 500 liters per boat. And it is very good opportunity, sir. We would love to have it. And second thing that you are giving for the ladies is 1 lakh rupees. And 1 lakh rupees is mainly needed for the ladies. And that is also good. And including that, we have got a...
My brother, can you speak in Kannada please so everybody understands?
ಇವಾಗ ನಮಗೆ ರಾಹುಲ್ ಸರ್ ಅವರು ಕೊಟ್ಟಂತ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳು ತುಂಬಾ ಚೆನ್ನಾಗಿದೆ, ತುಂಬಾ ಅಗತ್ಯವಾಗಿದ್ದು. ಇವಾಗ 500 ಲೀಟರ್ ಡೀಸೆಲ್ ಸಿಕ್ಕೋದು ನಮ್ಮ ತುಂಬ ಹಳೆಯ ಕನಸು, ಅದು ಇವತ್ತು ಫುಲ್ಫಿಲ್ ಮಾಡ್ತಿದ್ದೀರಿ. ಇವಾಗ 500 ಲೀಟರ್ ಕೆರೋಸಿನ್
अब तो चलेगा, इनका 6 हफ्ते चलेगा।
May I have your lordship's permission to commence the proceedings of the court?
Yes. My esteemed colleagues on the bench, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General of India, all the law officers, Mr. Vikas Singh, President of the Supreme Court Bar Association, Mr. Pradeep Kumar Rai, Mr. Rahul Kaushik, Mr. Manoj Mishra, President of the Supreme Court Advocates on Record Association, members of the family of late Justice A.M. Ahmadi who are present here and those who have joined us virtually, learned senior members of the bar, ladies and gentlemen. In assembling together, we pay our homage and tribute to one of the finest minds and a true friend of our legal fraternity, Justice Aziz Mushabbar Ahmadi, former Chief Justice of India. He completed his mortal journey, having led a full and fulfilling life, on 2nd of March. Our country has lost a jurist of a historic stature. As a young adult, Justice Ahmadi wanted to join the Merchant Navy and was selected. However, the selection letter was opened by his father, who himself was a judge in the district judiciary under the erstwhile state of Bombay. His father disapproved of the idea, and as fate would have it, Justice Ahmadi ended up following his father's footsteps. He often said that he did not choose law, but rather the law chose him. Justice Ahmadi was a man of many parts. He played cricket with the noted cricketer Salim Durrani, who passed away exactly a month after him on 2nd of April 2023. Justice Ahmadi began his legal career in 1954 when he started his practice at the bar in Bombay and later enrolled as an advocate of the High Court of Gujarat after the reorganization of states in 1962. As a member of the bar, he was among the pioneers of the legal aid movement in Gujarat. His legal acumen and advocacy skills were recognized soon enough, and he came to be appointed as a judge in the City Civil and Sessions Court of Ahmedabad in 1964. Appointment to the City Civil Court in those days was a stepping stone to a call to the bench of the High Court. In an interview, Justice Ahmadi narrates that he had no inkling of his appointment, and when Chief Justice J.M. Shelat offered him judgeship, he took some time to consult his family and especially his wife. He wanted to know whether his wife would be willing to live the life of a judge's spouse. In the end, Mrs. Ahmadi agreed. His children, Huzaifa and Tasneem, told me that Justice Ahmadi had a poor sense of direction and would often rely on his wife to guide him to the destination. His wife, Amina, was truly his guiding light in life. With her support and partnership, Justice Ahmadi rose from the ranks and was elevated to be a judge of the Gujarat High Court in 1976, and thereafter a judge of this court in December 1998. Justice Ahmadi holds the distinct honor of handling the judicial process at all three levels of the judiciary. Justice Ahmadi served this institution with consummate dedication and a fierce devotion to fairness, equity, and justice for 9 long years. He assumed the mantle of the Chief Justice of India on 25 October 1994 and became the 26th Chief Justice of India. The records of the Supreme Court registry reflect that Justice Ahmadi was a member of the bench in 811 judgments, of which he himself had authored 232 judgments. Justice Ahmadi was at his inimitable best in the courtroom. As a judge of exceptional intellectual abilities, he made significant contributions to the development of law, advancing the cause of secularism, substantive equality, freedom, dignity, and liberty. Some of his notable judgments include S.R. Bommai, L. Chandrakumar, Indira Sawhney, and Keshab Mahindra, dealing with the Bhopal gas tragedy. In S.R. Bommai versus Union of India, Justice Ahmadi wrote a separate 37-page judgment in which he emphasized the importance of accommodation and tolerance towards vulnerable religious, social, and linguistic groups, and concluded that adequate provisions had been enshrined in the Constitution to keep, as he said, divisive forces in check. In L. Chandrakumar versus Union of India, writing for the bench, Justice Ahmadi held that the power of judicial review vested in the High Courts and in the Supreme Court, enabling legislative action to be subjected to the scrutiny of superior courts, was an integral and essential feature of the Constitution, constituting part of its basic structure. In Alauddin versus State of Bihar, he laid down the procedure to be followed by judges in the matter of sentencing in terms of Section 235(2) of the Code of Criminal Procedure, 1973. He said that this provision is salutary and must be strictly followed. He held, and I quote, "When the court is called upon to choose between the convict's cry, 'I want to live,' and the prosecutor's demand, 'he deserves to die,' it goes without saying that the court must show a high degree of concern and sensitiveness in the choice of sentence. It need hardly be mentioned that in many cases, a sentencing decision has far more serious consequences on the offender and his family members." Justice Ahmadi was not one to shy away from writing a dissent where he believed that it was essential. He, along with Justice S.P. Bharucha, dissented with the majority view in the acquisition of certain areas of Ayodhya Act, holding the act to be unconstitutional. Aside from being one of the finest jurists, Justice Ahmadi was a great administrator, for the case pendency dipped to an all-time low during his term as the Chief Justice of India. When Justice Ahmadi joined the Supreme Court, he noticed that the total use of computers in those days was hardly 3% of its optimum capacity, and they were merely being used as word processors. When he took over as a chief, he transformed the way the Supreme Court used technology. He introduced computerized cause lists and made formal and extensive use of computers in the routine functions of the law. He built on the skills and management principles which he had devised during his time in the trial court and developed a method of categorization and classification of cases. After the successful categorization of cases, he got the docket pendency analyzed and took the challenge head on. He often had the slogan, "Don't get scared by numbers." Lord Justice Harry Wolff, the then Chief Justice of England and Wales, who welcomed Justice Ahmadi as the honorary master bencher of the Middle Temple, London, referred to him as the case cracker due to his success in reducing pendency of cases in the Indian Supreme Court. Justice Ahmadi has set the bar really high for his successors to follow. Justice Ahmadi extended active support to young advocates and encouraged them to appear before him. He made digital copies of judgments available so that junior members of the bar, in particular, those who could not afford the high costs of procuring books, could access the floppies and the CDs prepared by the Supreme Court. In an interview, he said that the basic idea was to ensure that junior members will have the advantage of a well-equipped library for that matter. His first step in increasing access to the judgments of the Supreme Court aided in increasing access to justice. Justice Ahmadi firmly believed in promoting young talent. In 1995, he formally introduced the system of judicial clerkships at the Supreme Court by employing a then fresh graduate, Arun Kumar Tiruvengadam, now a professor of law, as a judicial clerk. Justice Ahmadi often relied on the judicial law clerks to assist him in research and was open to their ideas and opinions. His dedication and devotion towards law, coupled with the aim of imparting quality education and encouraging young law students, did not let him stop after his retirement. and he accepted the position of chancellorship at the Aligarh Muslim University. He was conferred with several international recognitions and honorary degrees. He was a member of the American Inns of Court and was conferred a degree of Doctor of Laws honoris causa by the University of Leicester, England. He was nominated to various international committees and led several delegations and missions to East Timor, Liberia, Bangladesh, and Zimbabwe. When I had been offered judgeship, I had the opportunity to seek the advice of Justice Ahmadi. He was one of the arbitrators of a 3-member arbitral tribunal where I was representing the Reserve Bank of India in a dispute with a Canadian banknote company. On the last date of the arbitration in Ottawa, Canada, we are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239AA3 balances between the interests of NCTD and the Union of India. Article 239AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, Thus, the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in lists 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say, the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239 AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating policies in the territory of NCTD would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of all India or joint cadre services between the union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 in list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution. Thus, part 14 is applicable to union territories. And 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Thank you, sir.
Lord, immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1. Whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule: the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications that require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia strictly speaking did not arise in the matter before us, but we thought Nabam, the controversy should be settled by a reference to 7 judges. So I'll now go to the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members